Welcome to Who Wrote That Up For You, a daily podcast that shines a light on the American justice system and its role in empowering the powerful to take from you. The justice system is the only branch of your government where an individual, rather than the collective, can make the system act for you. It puts power in the individual's hands, but it's broken and being used against you at a time when you need it most.
And welcome to Who Wrote That Up For You. I am Sonia Ebron, a co-founder at Courtroom 5.
And I am Deborah Sloan, the other co-founder at Courtroom 5.
Got a wonderful show lined up for you today. In a few moments, we will speak with Lloyd Comiter. Lloyd runs the Mediation Training Academy out of Florida to help grow mediators. And so we're going to talk a bit about what those training programs look like and how to become a mediator. Before we get there, Deborah, what is on your mind today?
I want to talk about a recent California Supreme Court decision. Years ago, the California Medical Association sued Aetna, the insurance company, and it accused them of unfair competition for terminating physicians from a referral service for referring patients to out-of-network providers. A Court of Appeal decision affirmed that, and so did the trial court. The trial court basically granted a motion for summary judgment, and the appeal court affirmed that. And basically, they said that the California Medical Association, which represents nearly 40,000 doctors, it lacked the standing to pursue a challenge to the policy because it was not directly injured by Aetna's policy. But and Edna said basically that, you know, you're not doing anything, but, you know, expanding resources on behalf of the members didn't amount to a loss of money or a loss of property. But the California Supreme Court overturned that, and it held that organizations like the California Medical Association had standing to sue for unfair competition under state law when they spend money and time to address potentially illegal conduct on behalf of their members. So they kind of, we don't just like kind of squeeze it in there. They did it. And so I like the decision they made, but it opens up the door for a lot of nonprofits now to address really some of the potential illegal conduct by companies and the effect of that on their members.
Yeah, standing is one of the most difficult things, I think, for certainly not, people who are not trained in the law to understand that you have to have an actual industry. You have to have a right to something and to have your interests injured. It's really interesting. I'm thinking about that as I was listening to the story there. I'm thinking about that, what some people call a conflict. The state bar associations do the same thing. You know, they don't want to wade too deep into this here, but they certainly have their lawyer referral programs, right? And I don't think there's the same interest. In other words, these big insurers that you have in the health profession, but there's certainly some conflicts there. And I think there are some lawyers who've had some issues with state bar referrals in the past. So that bears, California is a big state, and for the California Supreme Court to find that insurance company had standing, might shake some things up nationwide in that regard. So very interesting.
Yeah.
Unanimous.
Yeah.
My. Oh, that's going to, I'm going to have to check that out. My goodness. I might see spreading that news around a little bit. See what kind of trouble we can get ourselves into. That's great. That's great. Thank you for sharing that. Well, at Courtroom 5, we believe the courts belong to the people, in particular to the people who use them. And we, the people, are coming to claim our courts. So if you are in court without a lawyer or you need to sue someone and can't find a lawyer to represent you, get yourself over to courtroom5.com and give us a try. We hope to provide some relief for you there. At this time, it's my pleasure to welcome onto the show Lloyd Comiter with the Mediation Training Academy. Lloyd, thank you for joining us today.
Thank you, Sonia and Deborah, for having me on your program. Looking forward to sitting down and talking about mediation with the two of you.
Fantastic, fantastic. And so, we've chatted. We had an opportunity to chat with a number of mediators this season of the show, but not one who actually trains them. And so, we've got a real expert here. I'm going to want to get into some of what you do. But before we do, can you just share a bit more about your background? How did you come to develop your interest in mediation and in mediation training in particular?
So thank you. So my background starts back in 1991 when I became a Florida licensed attorney, and from the very beginning, I was always handling the small claims cases, the county court cases, more of the mom and pop disputes, the Judge Judy type disputes or Judge Wapner type disputes, and fast forward a few years later, I became a county mediator, where I'm actually working in the courthouse doing mediations as a volunteer, also doing private mediations. And then I've subsequently become a circuit mediator where I'm handling the bigger cases, and also a family mediator where I'm doing family mediations also through the courthouse. And so I enjoy working with the public. I enjoy working with the attorneys. I enjoy making the process work smoother. And then more recently, fast forward, I became a trainer where I'm a primary trainer for county, for circuit, and for family programs in the state of Florida, which is very regulated by our governing body that oversees the mediation.
Fantastic, fantastic. So you went from practicing law to training mediators. It seems to me, I mean, that's an interesting journey. Seems to me you'd make more money practicing law the traditional way rather than helping people stay out of court, right? What's the rationale there?
You know what? I love being a mentor. And I always tell my students in my class, once you're my student, you're always my student. And I love seeing the younger mediators grow and build on their skills. And one things I'm proud of having is in my program, I have a private alumni group page on Facebook where my students can join that group. And it's a way for me to connect with my students, stay connected with them, tell them about the recent news that's going out there regarding mediation, and just being a sound piece for them. And they can always pick up the phone and call me. I still practice law, but I'm more going into mostly mediation and mediation training.
Fantastic, fantastic. And so let's talk a bit about that training. If I want to be a mediator there in Florida, I don't have to go to law school first, right?
No, you don't. In fact, depending on what kind of mediator you want to become, you either have to have at least a high school diploma. If you want to become a county mediator, be at least 21 years of age, and you have to take up the county program and do a few other things. And if you want to become a circuit or a family mediator, you have to have at least a master's or higher, or a bachelor's degree with 100 mediations under your belt. So basically, you're becoming a county mediator first, doing 100 mediations, and then you qualify. There's other nuances too, as far as the training program. That's generally what is required. And most of the programs are all on Zoom these days, the Zoom platform since COVID. The Supreme Court is allowing these programs to be conducted on Zoom or in person. And, the county program is a 24-hour program, so it's over 3.5 days for me. And the circuit and family programs are 40-hour programs.
Got it. Fantastic. And so those are fairly short-term programs. What does the curriculum look like? What do I learn in that period of time?
So they're learning objectives that are implemented by the Florida Supreme Court. And some of those learning objectives, for example, are talking about the court system in Florida, how it's all set up, talking about different methods of dispute resolution, like litigation, arbitration, mediation, etc., negotiation. We talk about the different components of a mediation. What does a mediation look like? We talk about writing the agreement, and we have the students actually write a sample agreement. We watch a video of a sample role play of a mediation. Then we talk about the different rules and the statutes that pertain to mediation. We talk about confidentiality. the role and function of the mediator, communication skills. We talk about opening statements. We talk about framing the issues and persuasive techniques. We do basic legal concepts, a lot of insurance terms. And then we, of course, go over ethics. And then at the end of the program, and at the end of all the programs, everyone is a mediator in a role play, and everyone plays the role of a party or a litigant while someone else is a mediator. And we have role play coaches who are coaching these mediators in their sample role plays that they're doing at the end of the program. And then obviously at the end, I go over the application process and show them what needs to be done and how to get their mentorship requirements done.
Got it. Yeah, fantastic. And so it sounds like you do have to have a little bit of legal knowledge to be effective as a mediator, right? And you cover that in your programs there. But is it helpful to be a lawyer as well? I mean, do you have some advantages there as an attorney?
So in some cases, I would say yes, but in other cases, I would say not necessarily. Like in the county program, a lot of the people who come to my class are in the human resources field, work for government agencies, are non-attorneys, and do very well in the class. And when I use the breakout rooms for the group exercises, I try and put, let's say, for example, I have mediators who are in mediators in circuit or family, for example. So they already have the skills of doing mediation. And let's say I'm doing a county program. What I want to try and do when I do the breakout rooms is I want to split the mediators up into separate rooms to sort of help and give some more knowledge in the different programs. Or I'll have someone who has an insurance background in the two different rooms when I'm doing the legal terms with insurance. So I try and split the class up to make it easier. But a lot of the county students are non-attorneys. I just did a program in the Virgin Islands, and I don't think there was any attorneys in the class.
Yeah. Yeah, that's good to know that you will learn all the legalese, I guess, you need through your program. And so it sounds like there are three types of mediators, at least they're in Florida. There's the county level, there's the civil circuit level, and then there's the family
and there's
level.
also
Is that right?
There's also two more areas, but the ones that we just talked about are the bigger areas.
Yeah.
Then there's also appellate mediation certification and dependency mediation certification. But the big three areas are the county, circuit, and family.
Yeah. I have never heard of appellate mediation. So let me just put a note there to get back to it. I'm really interested in that. But the county sounds like the easiest. Would you agree? Something that it's almost an apprentice level mediation?
I would agree, because in Florida, all the counties have court annex mediation programs. So when you take the county program and you want to do your observations, for example, it's very easy to get your observations done because you're going to do a county program observation either where you live, or there are some counties in Florida that are still doing mediations on Zoom. So I had a student in Los Angeles on a recent program. She's going to be able to do her observations by Zoom in those particular counties. So it's easier to get your observations done on the county level and also on the family level too, because all the circuits have court annex family mediation programs through the courthouse.
Fantastic. And so if I'm interested in mediation, I'm going to get my training and then go in to be a county mediator. Can I make a living this way? Is there a sufficient customer base in any particular county to do it?
To be honest with you, I think the bigger areas are the circuit and the family. But we all have to start somewhere. We all have to get our feet wet, feel comfortable in our own skin, get familiar with the process and how it works. And by doing the county mediations first, you're meeting the attorneys, you're meeting the judges, you're meeting the court personnel. And ideally, you do a great job, and then people will hire you afterwards, privately, the attorneys. Now, are people going to knock down your door as soon as you get certified? Probably not. It's a matter of being out there. It's a matter of being out on LinkedIn, on Facebook, networking, and everyone has a niche, and you have to find your niche and go to that source.
Fantastic, fantastic. I suspect, given the overload in the courts these days, that a lot of judges are referring their cases to mediation to just sort of at least get them off the docket for a moment or two. Is that a good source for mediators to get business?
Well, in Florida in particular, this jurisdictional limits for county court back in January of 2023, so just recently, went up from $15,000 to $50,000. So all these cases that used to be in circuit court, which is the higher level court, between 15 and 50, those are now in the county level.
Wow.
So we're now only in July. So I'm guessing a lot of those cases really haven't hit the trial docket yet, the ones that were filed after January. So it really hasn't been an over huge amount of cases yet because I think it's still too soon. But in Florida, every case goes to mediation before it goes to trial. And in some cases, like for example, in Palm Beach County in South Florida, the eviction cases that are in county court, every stage of the case has an opportunity to go to mediation.
Fantastic. That's really good news. That's something I'd like to see replicated in some other states. You know, we have a terrible eviction crisis right now, and that would certainly help. Is there a difference in the success rates of mediation between county civil, circuit civil, and family?
I would say it's all generally the same. You know, there's some cases that settle and some cases that don't settle. And, you know, as the mediator, it's not our job to decide the case for the parties. It's not our job to decide who's right or wrong or who has the better argument. Our job really is to facilitate a dialogue and a conversation and make the process so they can communicate with each other. You know, certain cases just, for whatever reason, they don't settle, and other cases do. There's no rhyme or reason.
Absolutely. Understood that. And so what's the process and does it differ between those? I think you mentioned 5 different types of courts, at least, or claim types. What is the process of mediating a case?
So basically speaking, and let's talk about the county court level, because that's the 24-hour program. That's the easiest program, I'd say. So basically, you're going to the courthouse, whether it be in person or on Zoom, as the mediator. And again, each county does a little bit differently. But in some of the southeast counties, like Palm Beach County, let's say, for example, they have typically 3 or 4 volunteer mediators who are in the courthouse. And a judge, there's like Tuesday, Wednesday, Thursday, there's a morning and an afternoon docket. So it's 3 days, morning and afternoon. And actually one judge also does on a Friday now. And so they may have 70 to 90 cases on the docket. Now, not every case is going to have both parties there. Maybe some plaintiffs did not serve the defendant with the lawsuit, so they're not going to show up. Some people just don't show up. But the cases that there's 2 sides on, the next mediator in line of those 3 or 4 volunteers are going to take the case, take the parties to another room in the courthouse, sit down with them, give a little speech and a little opening statement. The parties are going to give their opportunity to give a little opening statement, and the mediator does their magic and ideally come to an agreement where the parties will enter into an agreement. It gets signed, it gets approved by the judge, and then everyone goes home and does what the agreement says. And then basically the mediator takes the next case. So even though there's 3 or 4 mediators, they may do 5 or 6 cases during that docket, or they may do 1 or 2 cases. It really depends.
So out of 70 or 90 cases, maybe 5, 10 at most would be mediated. Is that what I understand?
Maybe 10, 15 cases.
Mm-hmm.
It varies.
Yeah.
But not all 70 cases are going to go to mediation.
Right.
Generally speaking, you can have a few cases that are definitely going to go to mediation.
Got it. Got it. And so do you see, I'm sure you see a lot of, or your mediators see a lot of pro se litigants, a lot of people representing themselves. In those cases that go to mediation, are there unrepresented parties on both sides, or is it usually a lawyer or a represented party on one side and an unrepresented party on the other?
So
what do you see?
It's a little bit of mix of everything. So the bulk or a lot of the small claims cases are credit card collection cases, where the credit card company or a collection agency has bought the old credit card debt and they are suing people who have not paid their credit card bill for whatever reason. The bulk of those cases, you have an attorney representing the plaintiff, the credit card side, and then the defendant typically is not having an attorney with them. You have those kind of cases. Then you have some cases where you have two attorneys on both sides. And you have some cases where it's two pro se litigants on both sides. Those are not the credit card cases. Those are you typically maybe a breach of contract case, maybe neighbor disputes, things like that. But
Yeah.
you see everything in small claims court.
Certainly, attorneys in those situations are more familiar with the mediation process and the law than the unrepresented party they may be facing. Is there a requirement for the mediator to sort of level the playing field in some way, or to protect the unrepresented party, or is it just a free for all there?
Well, I wouldn't say it's a free for all. We have some guidelines that we have to go by, some ethical standards we have to go by. We have to treat everyone equally. We have to be neutral and impartial. We can't show favoritism or bias towards or against one or the other party. Some of the techniques that mediators may use, if we see, for example, one side is bullying the other side, maybe we're going to separate them and go into a caucus. We're going to go into a caucus and caucus is a private session, a private opportunity to speak without the other side present. So maybe we're going to talk to one of the parties in a caucus when we're talking about offers and demands. We're going to do that in private session. So we try and even out the field in that respect, that we don't want someone taking advantage of someone. But we're not anyone's advocate when we're in mediation. We can't give them legal advice. So we have those restrictions. And we're also, if the party does not understand how an agreement's going to affect their rights, we have an obligation to let them know they have a right to speak to an attorney.
Yeah, absolutely. Absolutely. Is there any training provided or any preparation that a pro se litigant, an unrepresented party, could take in preparation for a mediation session?
Well, like on the clerk's website, they have a Q&A section on mediation. What is mediation? What can you expect in mediation? The paperwork that gets served on the defendant talks about that you're going to be going to mediation. And then you can certainly take a program if you wanted to, but I don't see that happen too much. And then obviously you have literature, you have videos, you have sample mediations on the different websites that are out there. So there's ways to see what happens in a mediation before you actually get there, if a person is interested in getting educated before they walk into the courtroom.
Yeah. Do you talk with the mediators that you train about the perspective or the needs of unrepresented parties? Is that a part of the discussion or curriculum at all?
When we talk about the ethics portion, and throughout the program, we talk about this trying to level out the playing field. We talk about the need to let them know that they have a right to speak to an attorney if they don't understand how an agreement is going to affect them. So I do go over that with my students.
That's fantastic. That's great. Do you see, what are the rates, I guess I would ask, out of those, let's say 10 or 15 that might go to mediation during a particular docket? How many of those actually reach a settlement during
I would say the majority of them do reach a settlement. At the end of a docket, how many cases actually are set for trial? Maybe 2 or 3.
Interesting. Fantastic.
The bulk of them settle. And it's just a matter of the case. I mean, a lot of the eviction cases settle. A lot of the credit card cases settle. So I would say the majority of cases do settle at mediation.
That's really fascinating. And you're talking about folks who are either referred to mediation or decide to mediate, generally on the eve of trial. It's either settle, right, or go to trial. And so you've got folks here who are looking at an opportunity to settle out of court, right, do mediation or go to trial, which is always terrifying. You never know what, the outcome's going to be there. I imagine, folks feel the ability to maybe make their case a bit easier in front of a mediator than they would in front of a judge or jury. Do you agree?
I would tend to agree, because in the mediation, we're just sitting in a room. We don't have the judge there. We don't have a deputy there or the bailiff. There's no court reporter there. We're just sitting around a table having a conversation. We're just talking. We're calling each other first names, maybe. It's a very relaxed, comfortable atmosphere. Whereas in trial, the judge has to follow the law. The judge can't take sympathy into account. So although I hear what you're saying and I feel for you, and you lost your job, and you have health issues, I can appreciate that. And in mediation, we can talk about those things. But at trial, it's not necessarily going to come into play in the judge's decision, because the judge has to follow the law.
Yeah, yeah, absolutely. And to the extent, it can be a friendly resolution, you'd rather just do it in mediation that way than have to
I think
deal with
so.
it in trial. Yeah.
I think so. Because in mediation, you control your destiny.
Yep. Yep.
You and the other party have 100% authority on how you want to resolve that case.
Yeah.
But when you go to trial, that 100% drops down to zero.
For sure. For sure. Absolutely. Do any of your mediators track the compliance with the settlements they facilitate? Is there a sense that, folks follow the agreements they've made, or do they end up back in court with broken agreements? How does it go?
So the broad answer is no, we don't track it.
Yeah.
However, when there's an impasse, a no settlement, I file a report. Even if there's a settlement, I file a report. If there's a settlement, the case is over. Nothing really ever is going to get filed in the courthouse anymore. If there's a no settlement, the case is going to continue on. If there's a settlement and someone doesn't do what they're supposed to do, then the other side's going to file paperwork in the courthouse. Once I file something in the courthouse, I'm on the portal. So when people file things, if they don't delete my name or don't send it to me, because I'm no longer I'm just a mediator, I'm not a party, I'll sometimes see pleadings come into my inbox where people don't adhere to the settlement agreements. So occasionally I see that, not too often, but occasionally I do see that.
And by and large, though, I imagine you don't see that. Folks have just, settled the case and they're off on their merry way. Is that right?
Most of the people settle the case and make their payments over time, or write a check right there and then, or in some fashion they resolve the case and it's over with.
That's wonderful. That is fantastic. I think you certainly made the case for mediation. Paint the alternative. What would the court system, the justice system, look like on the civil side in the absence of this sort of alternative dispute resolution? What would it look like?
Well, you don't know when trial is going to be. You don't know if the courthouse is going to shut down for another pandemic. You don't know if the judge is going to schedule trial for when you want to be on vacation or when you have to go to work. There's different procedures. We call it discovery, going back and forth. Maybe there's hearings and motions that the judge has to hear. I recently did a case where I was representing the plaintiff. The case was filed, I want to say, in 2020 or 2019. COVID hit. For lots of reasons, we finally went to trial in, I think, February of 2023. So it's a longer process, and it could be a more expensive process. And it's out of your hands, especially in these small claims cases. I like to say that if they don't settle, sometimes depending on the facts, they get legs of their own, and then it just keeps going, and you can't control it. It gets out of hand. Whereas in the mediation world, you can call me up, Lloyd, I got a case. Deborah and I have a case against each other, and we want to go to mediation on Monday. Do you have any availability? And I say, how about 2:00? And you say, great. We do it by Zoom. Monday, we can resolve our case.
That's
extraordinary.
extraordinary.
You can call me and say, you know what, Lloyd, we want to go to mediation tomorrow at 4:00. Do you have time? I know it's Friday, but do you have time? Yes. Let's set up a Zoom. We go to mediation, and we can maybe resolve the case tomorrow.
Way to go. Way to go. What does that cost for Deborah and I if we needed to have a mediation session? And who pays?
So typically, the parties are each paying the mediation. They're each splitting the case for the mediator's fees. And it's interesting you asked that, because I couldn't settle my own case. So I reached out to some people that I know. And and I was getting their price range of what they charge, so I can let my client know and I can let the opposing counsel know. I've seen fees as low as $250 an hour with a 2-hour minimum, and I've seen them as high as $550 an hour with a 2.5-hour minimum, and then everything in between. Now, granted, that's a circuit case,
Yeah.
so we're dealing with bigger dollars, but generally speaking, that's what it is. So you see all sorts of things.
And that's the total cost of the mediation session. Who pays? Is it
Typically
split
both
evenly?
parties are going to pay. Both parties are going to
Mhm.
pay equally, unless during the mediation one party is agreeing to pay the other's fee or a portion of it, or maybe I recently got a case where I was asked to do the case pro bono, no charge to the clients, and so I'm doing that. So no one's going to be paying that fee. Sometimes you'll get a case where a judge will enter an order saying so-and-so has to pay the mediator fee because maybe they scheduled it beforehand and they didn't show up. So now as a part of the sanctions, the judge is ordering them to pay the second go around.
Wow.
But generally speaking, going into the mediation, everyone's paying 50-50.
That's fantastic.
So
That is great.
if a party so someone's charging $250 an hour with a 2-hour minimum, each party's paying $250 for 1 hour of time.
Mhm. Extraordinary. I am grateful that mediation exists. We serve people at Courtroom 5 who are in battle dealing with litigation, and it's really difficult. Not just for unrepresented parties. Obviously, you know how difficult it is as a litigator, and so just really glad that you exist and that you're helping others exist. And so really appreciate your work there. Lloyd, I want to just share your website with our viewers. That's the Mediation Training Academy.com for those who want to learn how to be a mediator and get certified in Florida.
And let me just say one more thing, if I can.
Sure.
You don't have to be a resident of Florida to get certified. I've had people in Los Angeles. I've had people in Canada. I've had people in Nigeria take my classes. I've had people in the Virgin Islands take my classes. So you don't have to just be a Florida resident to get certified.
Fantastic.
And just because you take the class doesn't mean you have to get certified. You can just take the class just for the knowledge.
Exactly, which I'm sure is very valuable in negotiating, life situations as well. That's fantastic. Where else can people find you online, Lloyd?
So I'm on LinkedIn, Mediation Training Academy. I'm on Facebook, Mediation Training Academy. And then, of course, my website is www.mediationtrainingacademy.com, which you have on the screen there.
Extraordinary. Fantastic. Lloyd, thank you so much for joining us. Really appreciate you sharing the knowledge about how to become a mediator and just all the mechanics of making it work. Really appreciate your work.
You're welcome, and thank you for having me today.
You bet. That is great.
That
That's
is fantastic.
highly instructive. I mean, I have not wanted to be a mediator. I don't think I have the temperament for it, frankly. But I don't have the temperament to be in mediation, much less to help other people do it. But I think it's a fantastic alternative, and certainly something that should be more widely available. That is
I
fantastic.
never thought of that at all. How, I just thought somebody was a lawyer and then they became a mediator. Boom.
Yep. Yep. Exactly.
So, wow. Okay.
You don't have the temperament for it either. I know that. All right, Deborah.
No, at the end of the day, I do not.
You do not. Yep. What do you have? What do you have for us?
I have a question. What is the main purpose of a motion in a legal case? The main purpose of a motion is it A, report to the judge about issues in the case, B, request a specific action or ruling from the court, C, communicate with all parties in the case, or D, lay out the issues involved in your case? And the answer is the main purpose of a motion is to request a specific action or ruling from the court.
That's great. I
So
know
you knew that
people.
answer, right? You knew
Yeah,
that
I
answer.
have seen some really interesting motions over the time I've been looking at that, which absolutely try to do all of those other things as well. So good to point out the primary purpose of it. You want a
Yeah.
specific order. Fantastic. Thank you for that, Deborah. That's all we have for you today. Thanks as always for joining us, and we will see you next time.
Are you feeling beleaguered, angry, or afraid, as if things are spinning out of control and you're powerless to stop them? It's easy to just let things slide and hope they don't get worse. But they often do get worse. The thing is, you're not powerless. Our courts belong to us, and their purpose is to give power to the powerless. Don't let your grievances pile up without redressing them. You can handle this in court. Or, if someone takes you to court, you can take them to school.